Hey everyone, this is Sherry Rockwell of Sidley and Austin. I'm the chair of the California Lawyers Association Privacy Law section, and I'm excited to welcome you to our October membership meeting. We are going to just tick through some of the upcoming events and opportunities for you to get involved in our section, and then turn it over to a really interesting panel, or not panel, but a discussion today about what drives the adoption of privacy standards in the marketplace. And that'll be Melanie Phillips of Urich will be chatting with Chetan Gupta at Twitter about this topic based on an award-winning paper that he has written on the topic. Okay, so, and there is a self-study MCLE credit for this webinar based on their discussion. What is an MCLE is, I just want to update you on some of the exciting things happening in our section. First is we're growing. We, as many of you know, we started only a year ago, and we have 1,000 members, and that is really phenomenal. And thank you to everybody for joining and helping us develop the section. The renewal statements will be coming to you in November, and I hope you'll all sign on again, because we have so many big plans that I think you'll find it to be a really rewarding experience to be involved. And I'm going to talk about some of those plans now. Probably the most exciting thing, well, not the most exciting thing, but one of the more exciting things that we are going to be rolling out is we've developed committees to address Cpra rulemaking. And these committees will be under the umbrella of our legislative committee. There'll be 4 subcommittees that will be topic-based, and active privacy practitioners will have a chance to really dig in and comment upon draft Cpra regs and or maybe produce some other written materials. We unfortunately probably not going to be able to produce anything for the November 8th deadline that the agency has set for these preliminary rulemaking submissions. But as those of you who listened to my interview with Ms. Urban, or if you've been following what the privacy agency is saying, there will be informal hearings, and then they're aiming to get some draft regs out early next year. So look for an email from the privacy law section if you're a member about how to sign up for these subcommittees. We are screening a little bit just because we do need people who actually have experience working with CCPA, because the regs are very technical, and we want to just make sure that we're able to give substantive feedback. Anyway, look for an email, and then we'll also be posting that on our social media site, on our LinkedIn page, and on our webpage. So we're very excited about that. We envision the work will commence at a meeting on October 29th, and then probably it will be a multi-month commitment, probably through May at least. But a great opportunity. We're hoping to make the groups balanced. So you'll be talking to people, if you're in a law firm setting, you'll be able to meet people who are in-house, hopefully people from the nonprofit sector. We really want to make these reflective of the Bar Association, which is not just one type of lawyer. So it'll be a great opportunity to meet folks and collaborate and hopefully really push the ball forward. I will tell you that I told the chair of the California Privacy Protection Agency, Ms. Urban, I told her we were doing this, and she was very excited. So they're looking to us, and they're looking for our comments. So again, just check your emails and look on our LinkedIn page, which you should follow. It's in the chat now. So that's really a great way for you to find out about what we're doing. I just want to highlight a couple of other committees. Well, first I should say we have a new XCOM. The term of our inaugural XCOM ended, and we have just a terrific XCOM. We welcomed several new members to the XCOM, and everybody is excited and energized and really ready to do what they can to make this section kind of the voice of California privacy. We're uniquely positioned to do so, and that's really our mission and our focus. So committees, how can you get involved? So A was the legislative committee I told you about. Jen Oliver, who you also see on the screen, she's a partner at Mogan Rubin, and she heads up she does many things. She wears many hats. One is the important job of being secretary of our committee, so she's always active. But in her spare time, she also runs our publications committee. And that is just a terrific opportunity, especially for those of you who are younger lawyers or new in your career, to get your name out there. Our newsletter is sent to all of our privacy law section members, again, over 1,000 people, but also we put it up on our social sites and we can tag you. And it's just a wonderful way for you to get your name out there and to start developing or branding yourself as an expert in whatever type of privacy law you are interested in. So if you're interested in joining Jen's subcommittee, it's not a lot of meetings. They just touch base once a month, decide who's going to write what, and then you're on your own. And then you have a couple of weeks to write something up, and that's about it. So if you're interested, I think we have coming soon in the chat, we have an email address. There it is, privacy@calawyers.org. You can just send us an email and we'll plug you in to Jen's committee or any other committee you want to join. So the other committees, we have several committees, but I'm going to just highlight two more. One is our events and education committee. And as you can imagine, there's so much that we want to do on this front. We have so many ideas. We have privacy kind of deep dives into health law, multi-part seminars into children's privacy, which, as you all know, is just a huge hot topic. We have an XCOM member who's deep in this at Roblox. We have another XCOM member who works in DC on only these issues. So we have so much expertise in that area. But anyway, we're hoping to provide several of these multi-series deep dives into privacy law, as well as bringing you kind of the latest and greatest from California. What's happening? What's happening with the global privacy control? What does it even mean? How is it going to work? All those things. So we have so many ideas, but we really need help. We all have paying jobs, and we really could use a lot of help in helping to produce these, to find speakers, if you want to be a speaker, and to just work with all of us to make it happen. So if you're, and again, ground floor leadership opportunity, we are a startup section. A lot of these sections in California Lawyers Association have been around for decades, even though like they were formerly under the state bar umbrella. So it takes a long time frequently, honestly, to get to a position of leadership. We don't have that problem here because we're new. So encourage you to think about that. Another exciting project we have is we're partnering with Santa Clara Law and kicking off a mentorship program for law students interested in privacy. And if you're interested in serving as a mentor, please let us know. We expect it will begin in the next month or two. Not a heavy lift in terms of time commitment, and you don't even have to live near Santa Clara because, as we all know, we're all comfortable with virtual meetings. So those are some of the highlights of what's going on in this section. Again, encourage you to, if you look at our website, which we need to update a little bit, frankly, but it still has a good description of our basic committees, but there's many more forming. And yeah, just invite you to join us. Okay, so that's just an overview of what's going on. I'm going to turn this meeting over to Jen, and she's going to introduce our speakers, and then our speakers will take it away.
Thank you, Sherry. Hi, everyone. So before I introduce Melanie, who's going to introduce Chetan, I want to let everyone know if you have questions, you can feel free to put them in the Q&A. There's a little Q&A button on the bottom of your Zoom screen there throughout the presentation. We'll wait until the end to take the questions, but feel free to put them in the Q&A box at any time. And once the back and forth between our panelists has finished up, then I will go ahead and moderate any questions that you have. So Melanie Phillips is a member of Oryx's Cyber Privacy and Data Innovation Group. Her practice centers around incident response, consumer breach litigation, and regulatory enforcement actions. With more than a decade of litigation experience, including in key areas of trade secret employment and consumer protection, she has a holistic understanding of the key drivers of privacy and security in organizations big and small. So welcome, Melanie.
Thanks so much, Jennifer. Really thrilled to be here today with Chetan Gupta to discuss his 2017 paper, The Market's Law of Privacy, Case Studies in Privacy and Security Adoption. The paper won the Privacy Papers for Policymakers Award from the Future of Privacy Forum, and Chetan was invited to present the paper at the US Senate. Currently, Chetan is senior legal counsel on Twitter's privacy and data protection team. At Twitter, he counsels a number of internal teams on using data respectfully to meet consumer expectations, including the purposes of data science. Chetan has 2 law degrees from Oxford and Berkeley and is licensed to practice in California and India. And the paper that we'll be discussing today set up the hypothesis that from a consumer perspective, any meaningful improvement to privacy and security, for example, HTTPS, replacing HTTP, end-to-end encryption for messaging apps, is driven by a small number of dominant businesses, or even a single local business, as opposed to actions that consumers take themselves or resulting from changes in law. His paper posits that tangible improvements occur when consumers have to do very little or even nothing, as opposed to requiring consumers to read lengthy privacy policies or take other proactive measures to protect their rights or improve their security. Chetan's currently working on a new paper that will look at how new developments continue to bear out this hypothesis, including examining how Apple's iOS 14 changes have driven privacy improvements across tech companies more effectively than through legislation, and have forced companies to re-examine and change their privacy practices, and how Google's move away from third-party cookies and towards federated learning is likely to result in privacy improvements from a consumer perspective. So, Chetan, thanks so much for chatting today. Talking about your 2017-2018 paper, how did you arrive at the initial hypothesis? Did you work through other ideas as you were coming up with your hypothesis that weren't borne out by your case studies, or how did you kind of refine it as you were developing it?
Thanks for the introduction, Melanie, and thanks to CLA for having me. So I think I came upon the idea in quite an interesting way. There's a writer I like called Nassim Nicholas Taleb who writes interesting things, and one of the things he writes about is intolerant minorities and how they can drive societies. And the example he used was like all the orange juice sold in the US is kosher, and that's because kosher populations will only drink kosher juice. Non-kosher populations don't really care. This has the default effect of making all juice, nearly all juice sold in the US kosher. So that got me thinking, would a similar argument apply for privacy or security if you have a really strong vocal group of people who are not willing to accept or want particular things? Could they drive standards for a whole industry or sector or all of society? And of course, the sort of more romanticized version of this hypothesis is, oh, you have one single privacy advocate who really sticks up for stuff and they produce something groundbreaking. But when I started digging into it, I couldn't find any tangible real life examples of that sort of thing happening. You could point to Max Schrems now and say maybe he's the real life example of this. But the examples I sort of found that fit the model were more in the space of single, largely dominant actors doing something that caused industry-wide change. And to your question, there were things that fit the hypothesis, and there were things that didn't work, and we sort of thought about why they didn't work. For HTTPS, Google decided that it would change the way it ranks search results based on whether a site had HTTPS enabled or not. And that was like flipping a switch for the internet. It seemed to have compelled so many people to move over to HTTPS, and Google also made it like easy by providing some tools to allow people to easily do that. And it's interesting, like just before I hopped on this call, Google has a public facing page that allows you to see how much of traffic moving through Chrome is now HTTPS. That's actually 100% now. So it's totally flipped over to HTTPS. But there are other things. So HTTPS is an example of where it totally worked. Two-factor authentication is sort of an example of where it doesn't work. Because lots of people have tried turning two-factor authentication on. Twitter has two-factor authentication. We have a usage rate of about 2%. Globally, 2% of people turn on two-fac, even though it's a huge improvement to the security of your account. You can stop most account takeovers if you have two-fac. But it's not taken off. It's never taken off. And I hypothesize it's partially because it puts the burden on the consumer to proactively do something, and maybe that's just not the right spot to put the burden on, because people tend to be messy and people tend not to do. Even if you tell some people it's in your best benefit to do something, it doesn't necessarily mean that they'll end up doing it. So I looked at a few different things. I looked at HTTPS, I looked at two-fac, I looked at end-to-end encryption as another example. And end-to-end encryption again. It was like when one single dominant actor decided they're going to introduce, like WhatsApp decided they're going to go E2E end-to-end encryption. Today, like there's virtually no messaging app that doesn't support some variation or have it turned on by default.
The HTTPS adoption between 2014 and, I mean, it's been 7 years, right, since that the flip was switched by Google. So to truly drive, the market to that standard in 7 years, it's pretty remarkable.
Yeah, it's pretty crazy.
Right, and then I really, the contrast between that, the HTTPS adoption, which is company driven, right? You're setting up your website in one way, versus multi-factor authentication, where you're asking the users to sign up in a way that requires that, is I think fits precisely within your hypothesis that it's has to be a very low bar for the consumer to step over. In terms of when you were talking about Google's impact on the HTTPS adoption, you predicted a similar scenario would play out for EV SSL certificates and certificate transparency, again, because Google was driving the market that way. Have you done any follow-up on that to see if that has played out similarly?
So literally, as you asked me that question, I scrolled across every open tab on my browser. All of them have a lock symbol. So I anecdotally, I would say yes. I haven't done in-depth research, but anecdotally, like and I have a diversity of tabs. Not all of them are from a single website. So I'd say, yeah, if we looked into the figures, I'd suspect they moved the needle on that one too. And it's interesting, I read that they're actually trying to move MFA in a direction where it's not that you get challenged every time to provide the factor, or they're trying to do more work on the back end and lower the burden on the consumer. So I'd be super interested to see where they land. And it's also a contrast, right? Like I'm sure you have MFA at your law at Oric, and I have MFA at Twitter, and I use it 5 times a day, but I'm compelled to use it. I'm not going to say publicly whether I have MFA turned on my personal devices or not, but I suspect even for my many privacy and security professionals, the answer maybe we don't turn it on our personal devices.
Right. It's something that I'm always discussing with clients, while not disclosing whether or not I personally find it to be a barrier to entry or not.
Yeah.
Yeah, the multi-factor authentication, it will be interesting to see how that could become uniformly pushed out in a similar way. Like what actor has the power to push that? Maybe it could be something through App Store or similar requirements, but I guess it remains to be seen.
Yeah, for me, it almost fails the user friction test. Like it's not going to get there because of the amount of friction. And we use YubiKeys, which are really small devices. Like this is the key we have. That does lower the burden. I don't need to reach for my phone to input a code or need to look at something else. I just touch the key, and that serves as an additional authentication factor. So I think that's a step in the right direction, where you have the key plugged in or you have the key on you, and that's an easier way to have another factor. But I don't think YubiKeys are particularly cheap. So there's still some friction there.
Yeah, definitely. What about privacy-centered products themselves? So smaller shop, but privacy-centered products that are, trying to serve user demand for it. I'm thinking about internet browsers such as Brave or DuckDuckGo. Do you see those changing the landscape in material ways?
Yeah, that's a really interesting question, because I've used Brave. I actually think it's pretty good for a web browser. When I use someone else's computer, I'm like, why do you have so many ads on YouTube? Because Brave just blocks them out by default. But again, if you look at the percentage of web users on Brave, it's tiny. And similarly, like I guess maybe you're thinking of DuckDuckGo as an alternative to privacy, as privacy preserving search option. Adoption is just tiny. So I'm not sure I know. Like I would predict like they're not going to deliver tangible improvements because not enough people are going to adopt them. I guess what would fit my hypothesis is if Google launched Brave, is you would automatically see privacy improvements if that were to happen. But then of course I'm sure some people would say, well, Brave is not necessarily the right direction to go in. There are trade-offs for how you do web browsing, et cetera, et cetera. But my hypothesis would be Brave and DuckDuckGo would not move the needle in a meaningful way, though they're excellent products. Just like MFA is an excellent thing to improve security.
But they don't meet that barrier of consumer ease to consumer, or meeting that consumer experience.
I would actually say they're both easy to use. I will say, having used DuckDuckGo, I'd be curious to hear your thoughts too. I do find there's a difference in search results, or the quality of search results. I would say Google is better at surfacing relevance of search results sometimes. But for me, it's more of they don't have a large enough surface or pulpit to preach from.
Right.
So they're not able to reach 80% or 90% of internet users in the way a Google or an Apple or someone else is. Again, like maybe the way to think about this is, if Apple was to default to DuckDuckGo as the default landing page for search through Safari, or was to offer Brave as the default browser on its phones.
Yeah, and how that would change the landscape. Absolutely.
Yeah.
As you were writing your paper, it was just as GDPR was about to sort of majorly shift all of our worlds. And since then, the CCPA and CPPA have come into existence. How do you see those interacting with your hypothesis and kind of changing the landscape? Do you see them impacting corporate behavior in a way that it reinforces this, or changes it somehow in a different way?
I think GDPR definitely backs the hypothesis up, in the sense that a dominant player, the EU in this case, decided to make a change and sort of forced it on everyone, because even if you had a tiny exposure to the EU, you were compelled to make product or service changes. based on that, and even based on what I've seen at Twitter, the approach we ended up taking is not that, oh, the EU requires this, so let me give this to folks in the EU. Like, we ended up giving data access rights to everybody globally, because it can be more complicated to engineer a solution based on geography, or to take that approach rather than just giving something to everyone, or just revamping your business model to account for that. Though, of course, in that there's no soft adoption. It's a hard regulatory piece of legislation that compel people to do that. So I think the GDPR definitely fits the mold, in the sense just moved the industry single-handedly. The CCPA probably on the US scale, at least, because I'm sure many people on this call are sort of grappling with the issue of, oh, we have California, we have all these other domestic laws. Do we come up with a framework that sort of broadly reconciles their requirements and push something out based on that? But like, I think the CCPA legislatively empowered other states to go start thinking about similar laws. So I suspect it will have a similar effect to the GDPR, at least within the US. But I think one to wait and watch, also based on how enforcement goes, I guess.
Yeah, and it in thinking back to your original hypothesis of like, can an individual change privacy standards, the sort of the California ballot initiative process presents an interesting sort of procedure for somebody to take that approach. Obviously, there are some other organizing and potentially monetary principles at play there too, but an interesting question as to if that represents an example of an individual pushing for change that then has to be accommodated.
I should definitely put that in the newer update to the paper with due credit to you, because it's really interesting, right? If Taggart hadn't had a random conversation with an engineer at a dinner party, we wouldn't have gotten here. But yeah, I am not even sure he had a conception, or his team had a conception of privacy that they wanted to push forward, but it obviously got there through the process of writing the CCPA. But you're right, it's a pretty good example of. So I would say they had to co-opt the legislative process to give them a big enough platform to make that happen.
Right.
Yeah.
Definitely a partner, and it gives an example of his outrage or frustration or whatever after that dinner conversation, and just having the ear of people in the industry maybe would not have been enough. I mean, obviously he took a different tact, but I think it supports your hypothesis of one individual working just in concert or communication with a company maybe doesn't have power. So very interesting.
And another one that I think sort of sits halfway, and I think Sherry mentioned right at the start of this call, was like this global privacy control. Super interesting idea, but I feel like it's maybe a little user centric. It forces companies to build a bunch of backend stuff to honor and respect it, which I guess is good. Like, it's a simple one switch to fix it all kind of approach. So I'm not sure. I'm still thinking about where that would fit in the model.
Yeah, that'll be interesting to see how that develops and plays out. I mean, there's a lot of development in that area still, I guess.
I'm wondering whether it's more on the MFA side of the house, or more on the users don't actually have to do much to get this to work for them.
Right. It'll be interesting to see how that works. Yeah, great section for the next iteration of this paper. Speaking of the next iteration, you were thinking of a couple of specific examples: Apple's iOS 14 and Google's drive away from third-party cookies. Can you walk us through those and how you see them fitting into the hypothesis?
Sure. And to take a step back, and I guess it's helpful to describe what I'm thinking of as Apple's changes, but like broadly the set of changes that Apple made around tracking transparency and nutrition label requirements. And it's fascinating, and I don't think it's a secret that many people in this space were scrambling to comply with those requirements, and said it would have an impact on their business model. And I found it, I thought that it did fit the original hypothesis of, okay, this player who's incredibly well positioned because they serve as a gateway to phones is basically making a change that you could argue that it leaves consumers better educated about information collection practices and gives them more control. But Apple's basically able to throw the switch and say, guess what? You don't do this, you're off the App Store, which basically means your app is dead. And Google's followed suit, right? Like Google has said it will introduce some variation of both of these ideas. I think the nutrition label it already has in some form, but it'll introduce some variation of the ATT concept down the line. So I think Apple for sure bears that hypothesis out with ATT. Google with federated learning, I think it's too early to tell, especially because and I suspect this will tee up the next part of our discussion, but they've received a bunch of regulatory pushback on federated learning and whether it's truly a privacy preserving technology, or it actually allows easier identification of folks because you're bunching them into cohorts and it's easy for re-identification to take place in other parts of the ecosystem. But again, if a big player like Google was, and like Apple's had third-party cookie restrictions for a fairly long time now. So it's interesting that like Apple, which is a fairly big player in the ATT space, was not enough to kill third-party cookies in the web browser space. But Google could do it if they probably do it, given the amount of web traffic that flows through Chrome. So jury's out on Google. Apple, I would say, fits the hypothesis.
Great. I mean, if you go back to your HTTPS example, I guess we have 7 years to figure out if that changes it or not. And there's certainly parallels to draw between, the examples in your existing paper and those two that are great. And your regulatory reference there is exactly on point. In your original paper, you kind of pushed on how these market players were actually driving change potentially faster and more effectively than regulation. There's obviously been a ton of development with the FTC and enforcement actions in the interim. How does that change your thinking there, or does it in any way?
Yeah, I think one of the things that I talked about in the original paper was the FTC also drive towards this idea of, this thing is now so widely accepted as a standard in the industry that we can hold you to that standard without sort of explicitly calling it out in any formal guidance from us. And I think they have tried to do that in a few cases. But what's also interesting is that the FTC seems to be driving towards almost this common law of privacy and security, I feel, looking at recent enforcement actions where they are trying to signal to the market as a whole, not, I wouldn't say the provisions in the orders are directly tied to the conduct alleged in each situation, such that and I think at some point the commissions have publicly said this, we're trying to create a signal to the market that this is how we expect all players in this sector to behave, which would again, from a regulatory perspective, it's we will make a single change which should impact all people upstream and downstream. So that's been kind of interesting. Though obviously, like the FTC has enforcement priorities and other sort of balancing acts to deal with.
Yeah, and in my personal practice, I see state AGs dipping their toe into this water in different ways as well. And I think we're about to see how that plays out in California, and how that changes the discussion or impacts the standards and drives, corporate change as well. Will be an interesting question.
for sure. And novel enforcement. Like I know when we were in our side discussion, we talked about NYDFS. Like we see them trying to enforce privacy through crypto sometimes. Like we at Twitter had an incident relating to some people tweeting Bitcoin scams, and we got an inquiry from NYDFS, which took us by surprise. So yeah, if NYDFS decides to be the single actor that drives change, it'll be interesting.
Yes, I think you are not the only person to be surprised by the breadth of their interpretation of their authority.
Yeah.
But yeah, it is kind of changing the way people interact with their regulators or think about who their regulators are.
Yeah.
What other looking out at the broad landscape, do you have any other kind of predictions or interesting areas where you think you'll see how this hypothesis plays out?
I guess the one I'd be really curious about is just how cookies plays out and how device fingerprinting as an alternative plays out. And I think they're competing things, right? You'll have Google, but you'll also have regulators. And I think now with privacy, we all have this new angle, which is, I think, Melanie, when we were chatting, you'd actually brought this up. If you become a large enough player to single-handedly move the needle for your entire industry, do you have an antitrust problem? And I think that's a really fascinating question. So I also wonder will we see people like Apple and Google being more circumspect about doing these sorts of things in the future because it subjects them to greater antitrust scrutiny, or even like Facebook doing less of this because it subjects them to antitrust scrutiny? And I obviously I don't know the answer to that question. But it's an interesting one for sure.
Right. Yes, a lot of different threads of law flowing through this area right now, and I think trying to take all the various potential implications into account as you're making a decision about where to set your standards and how to develop them is certainly. I mean, I guess you would know from experience a very complex question. And then when you take into account user adoption or user ease of use, that becomes yet a different flavor. So I guess in your day-to-day, how do all of those weigh in?
Yeah, it's kind of interesting because at least when I'm doing my data counseling work, I do sometimes just focus on the formal requirements, right? Oh, we need an opt-in checkbox for collection of this type of data. But if I think about my hypothesis, an opt-in checkbox is probably, or like a checkbox is probably the worst way to actually improve anyone's privacy or security because it requires an extra step. We're not sure how many people read the text. We are not sure how many people read or comprehend many of the things that are shown to them. So arguably there's a tension there between, in a formal role as a privacy counsel, when you're counseling a client, do you steer them towards meeting the formal requirements of the law, or do you try and get creative and say think out of the box and try and do something which just improves things on the back end without necessarily presenting the user with a lot of choice?
Yep. Definitely all the hurdles to jump through in a day and in any given decision. Okay, I think we can turn it over to Sherry and Jennifer for any questions that have come through as we've been chatting here.
Thank you both. That was really interesting, fascinating, especially as an antitrust practitioner. I enjoyed the discussion about people always ask about the overlaps between antitrust and privacy, but in fact, there are quite a few tensions between the two. So I find that very interesting. We don't have any questions in the question box just yet. So if anyone does have a question for the panelists, please go ahead and put it in the Q&A now. If we'll give everyone a few seconds. But if not, I'm sure I join Sherry in saying, there she is, and thanking both of you for joining us today. I think it was a really fascinating discussion, and we appreciate it very much, and I'm sure our members do as well.
I actually have a question. So one thing, a question for both of you. How do both of you keep up with everything happening in the privacy universe? What are your strategies? Maybe, yeah, just tell it. Like, what are you reading? What do you reliably look to when you wake up in the morning to see what's happening in the privacy and cyber landscape? And where do you find your kind of deeper reading?
I'm happy to go first if you want, Melanie. So I definitely look to industry groups like CLA or FPF or IAPP as one source, and I'll attend some of those, especially the more tilted towards in-house counsel groups that tend to have a perspective read on. I think your perspective on new legislation developments can be pretty different depending on whether you're outside counsel or in-house counsel. So especially industry groups that focus on that stuff. And I was actually going to say we actually lean heavily on people like Melanie and their firms to sort of keep us posted on things that will impact us in meaningful ways, because speaking candidly, as an in-house practitioner, a bulk of my time is consumed by counseling my clients on issues with their actual products and services. So I am not necessarily thinking about subclause C to clause D of whatever piece of legislation has come across on that day.
Yeah, I think at our firm, we were just accept that we're going to be drinking from a fire hose pretty much constantly. So just trying to, have yourself on enough lists where you're seeing developments come through in real time. And then I really rely on conversations with my colleagues and with, in-house counsel and people in the industry to keep me, abreast of how they're thinking about it. Because it's one thing to, read a decision, and then it's another to think about how that's impacting the different factors that we're all thinking about. So I actually find forums like this incredibly valuable to hear somebody talk about how they're thinking about the intersection, the way that privacy, security, antitrust, all of those issues kind of play together, and how they see them developing.
Thanks, that's helpful. I'm always curious because I like that fire hose analogy. I think it's apt. Jen, I don't know if you have anything to offer.
Yeah, I have a question from the group. How much do you find that engineering team members are driving capabilities that they believe are the quote unquote right thing to do?
I can take a shot at that. I generally try and come from a place of good intent when I'm talking or counseling with engineering team members, and I feel like this might also be a culture thing where, Twitter, for example, has said privacy is a fundamental human right and has made it a company-wide priority, and so it sets the tone from the top. So it's more natural to have those conversations, but I often feel like our job as attorneys is also to educate engineering clients on the fact that the trade-offs may not be as drastic as they feel they might be. That I am not telling you can absolutely never collect or process this data. There are meaningful ways to deliver a better all-around product without sacrificing your ability to do something with this data or to analyze it. So I would, if I had to put a number on it, I would say 70 to 80% of the people I interact with on the engineering side are actually want to do the right thing in terms of building better product in a way that respects consumers' expectations and private. It's rare to encounter someone like I don't care about your goals. I'm just trying to I just want to ship this thing. Don't stand in my way.
Yeah, I'd agree. I think your point is a great one of the tone at the top, and I think you can see corporate clients who have that mentality and have represented that mentality, and I do think it flows down. And yeah, so but I do also think I think it supports Chetan's overall hypothesis that, sitting as a large player and saying we believe in privacy can kind of push others to adopt that. So I think I think you could probably take that as a position and look and see how many, if Twitter adopting that then drove other social media companies to do it, or if, where out of all the major players, how many of them make that kind of statement and representation.
Yeah, it's interesting. I mean, I have a follow-up question, which is, so where do their beliefs come from? I think you've addressed this a little bit.
Yeah, I'd say one comes from the selection effect of joining a company, which is sort of saying it out loud in public as a priority. It also comes from naturally whatever your background you're bringing to the table, whether like the program I went through at Berkeley had a cross-functional thing where they offered courses with a mix of engineers and lawyers. And I think like if you've been through that sort of system, you're more likely to be thinking about issues in that way, which is incredibly helpful. And I have this firm belief that this field is going to end up merging, like privacy engineering and privacy legal. Lawyers are going to need to talk. Privacy engineering and privacy engineers are going to need to talk law. It's just going to have to happen. And obviously, like you can have company initiatives that drive those beliefs. So we have a program called Doves where my team runs it as a sort of basic education on what privacy and data protection means. You can sign up and be a Dove, you get some free swag, but hopefully you also walk away with some like basic ideas about privacy and agree to be like a steward in your part of the organization.
That's great. All right, and hopefully we'll see more universities and certificate programs follow suit, because that sounds like a great idea. I don't see any additional questions from the audience. I do want to thank you both again very much. Great discussion. Oh, wait, I have one more. Do you think of the value of leading the law internationally?
I'm going to interpret that as, is there a value to being?
I think, yeah, maybe like what,
mover?
yeah. Do you think there is value in the law internationally?
Yeah, because I like look at the GDPR. Like every new nation writing a piece of privacy legislation inevitably ends up looking like some version of the GDPR because it dominates the imagination. And from an industry perspective, it kind of works because most people have done the work to comply with the GDPR. So it's industry friendly too to think in that way. But yeah, I think so. Melanie, what do you think?
Yeah, I agree. I mean, I think you could pick spots if you have a particular need that has developed or issue that's developed where you could try and set yourself apart. But I think you have to have a pretty robust enforcement vehicle behind you if you're going to be distinct from everybody else to really force adoption of that particular piece.
Chetan, this is from one of our audience members as well. Can you comment at all about the state of privacy law in India?
Yeah, and it's an interesting example, right? Because if you look at India's law, it definitely has concepts. There is an equivalent to data processors and data controllers. They have chosen to call them something else. So I would argue that places like India can just take a step back and say, should we just adopt the GDPR? Should we just write exactly the same thing? And I would argue it makes life much easier for both the state and those that's seeking to regulate if you just do that, rather than trying to come up with data fiduciaries or other concepts which are functionally the same thing. So from an ease of adoption perspective, that's what you're trying to do. I would argue that you see many of the same ideas: legal basis of processing, transfer data outside, being using some variation of SCCs or model clauses or stuff like that. You could easily just, and I feel like globally we need to standardize this stuff now. We're at the point where it'd just be easier if, as Melanie said, we would be out of a job if people did that. But yeah.
Right. Well, to your point, and this is also from the audience, given the patchwork of privacy laws in the US, do you think our federal law or adopting a federal law similar to GDPR would be a better choice here in the US? And I guess that's for both of you.
As somebody who has worked through the patchwork of state breach notification laws as many times as I have, really sometimes, yes, just one standard would really help. I think it also helped consumers or individuals understand what their rights are and how they should expect to be treated. Because it's very odd that in like North Dakota, your birth date matters, and in Colorado it doesn't. In thinking of those frameworks, so I think it would a federal standard would give people a better understanding, and when you have a better understanding, you can better police or enforce it. But yes, also don't put me out of a job. So there's pros and cons.
I'd just say plus one to all of that.
All right, anything else from our audience? Going once, going, oh, one more. Okay, I'm impressed by the policy work being done by the community in India. The national treatment of sensitive data such as health information is one obvious area. Do you agree?
Sure, and I mean, my prior statement was not to say that countries shouldn't do what's right for them, or if there are new innovations that things you can improve on, you can always improve on stuff. But I guess how do you take that idea of sensitive information and health and sort of apply it in a meaningful way for a country as large as India and make sure that it delivers meaningful benefit to both the population and to like industry actors in the space?
All right, anything else from the audience? Okay. All right, so one more time, I'll thank you both again for an excellent conversation. If Sherry doesn't mind, I will add on one more quick announcement to the group. Sherry mentioned several times to look in your emails for emails from us about joining committees and various events. Please do, if you're not getting emails from us, check in your spam folders. We are working and trying our best to address issues with our emails from CLA going to spam, but please check your spam folders, see if the calawyers.org emails are going to your spam. If they are, please change your rules and try to get them moved into your inbox going forward so that we can communicate great events like this one to all of you and encourage others at your organizations and firms to do the same. Anything else, Sherry?
No, that's it. Thank you so much for a fascinating discussion that, of course, as my mind is going about like more events we can offer to our membership that that you've flagged in the course of this discussion as useful to privacy lawyers and engineers. But thank you so very much.